Hello. Good afternoon to everyone. It's a pleasure and an honor to share this day with you at this great university. I thank and congratulate organizers and sponsors. My name is Gabriel Seijo. I'm a partner at Sescom Barrio, a Brazilian law firm, and I'm also a member of the ICC Global Commission on Arbitration and ADR, and I hold a PhD from the São Paulo Catholic University. It is said that Sir Winston Churchill used to sleep every time a certain young member of parliament spoke at the House of Commons. So one day this young MP approached Sir Winston and told him, "Sir Winston, do you have to sleep every time I speak?" So Sir Winston said, "No, I do not have, but I do want to." So this is an after lunch panel, but I'm certain that we'll neither have nor want to sleep because we have such a stellar panel with us. On my right, I have Sapan Gupta. Sapan is Global General Counsel of ArcelorMittal, member of the Global Management Board of ArcelorMittal, and holds degrees from Delhi University, LSE, and Harvard Law School. I also have with me Jaroslav Kudrna, Jarek. Jarek is the head of International Arbitration and Investment Protection for the Czech government. And among other degrees, so there are so many, he has degrees from Sciences Po, Strasbourg University, the New York University, and Charles University. And also we have Catherine Young, who is legal counsel at Shell in the UK, and holds degrees from the University of Nottingham, Nottingham Law School, and BPP Law School. This is a panel about the client's view on arbitration. It has always been said that arbitration is as good as the arbitrations are. But in the past few years, I have heard a different version of this. Arbitration is as good as the client thinks it is. So this is our chance to hear our clients. At first, we will hear each of them exposing the pros and cons they see in arbitration. Then I will pose some questions, some very open questions, to have an interaction, an informal conversation. At last, we'll hear the audience. There will be the part, everything you always wanted to know from your client and were afraid to ask. So please take the opportunity and interact with this wonderful panel. So, not to lose any more minutes, Jarek, which are the pros and cons you see in arbitration?
Thank you, Gabriel, and good afternoon, ladies and gentlemen. It's a real pleasure to be here, and I would like to thank Xuan and other organizers for inviting me. And before I go into it, I just need to state that the views expressed here are only mine and shouldn't be attributed to my government. So perhaps just to note that the Czech Republic is, with 42 investment cases, the 6th most frequent respondent worldwide. But fortunately, the Czech Republic has won 31 out of the 39 concluded arbitrations. And yeah, given it sounds like a lot of cases, when I saw that Sapan is coming from ArcelorMittal, I can disclose that one of our investment cases was even with ArcelorMittal. But what's good that it was a settlement, so we can sit here long before my time, but we can sit here in peace. So I had the honor to work on 15 of these most recent investment cases, and given my position at the head of investment arbitration, I will give my pros and cons with a particular view of investment arbitration. So I think that the biggest advantage of investment arbitration, particularly from the investor's point of view, is that it provides a neutral forum with an independent decision maker who has the trust of the investor. And I say so because investors might distrust the local courts, and they might not want to really bring their claims to local courts. Because even though, of course, judges are supposed to be independent, investors might worry about political influence in high-stake disputes with the state in some countries, unfortunately. And this is not a hypothetical issue. Just for example, I have looked at the recent Eurobarometer survey, which is done within the EU states, and it showed, for example, for Central and Eastern Europe, that the companies which were asked within the survey have not really perceived very highly the independence of domestic courts. And from the perspective of the state, we do agree to arbitrate these investment disputes because we believe that in combination with the substantive protections offered in investment treaties, this whole system serves as one of the factors in attracting foreign direct investment, mainly by signaling to the investors that the state is confident in its public administration in a way that it will comply with these international standards and that compliance can be reviewed in this neutral forum. And I believe that another key advantage of this system is that the decisions are legally binding and easily enforceable, as we heard also this morning under the New York Convention or the Exit Convention. So far, so good, but I think it's important to emphasize that there are also some significant downsides coming from the fact that there is this decentralized ad hoc system which is used for investment arbitration. And one issue I see from the state perspective is, unfortunately, the conduct of the arbitrators, and particularly double-hatting, which for us has been seen as one of the major flaws of the ISDS system, which has particularly negative impact on the legitimacy of the system. And I believe so because I see it as quite disturbing when you have someone who sits as an arbitrator and acts as a party representative concurrently or close to each other, because this can, I think, arguably undermine their independence. And to give you just one example from my recent experience, for example, in these solar arbitrations against the Czech Republic, we had Gary Bourne as acting as the arbitrator appointed by investors in all these cases against the Czech Republic, while at the same time, his law firm has been acting as a counsel for other investors in solar cases against Spain. And then, perhaps not so surprisingly, Gary Bourne dissented in all 6 cases against the Czech Republic where we won. So I think that this double-hatting raises a concern that the decisions of the double-hatting arbitrators might be influenced by their own agenda. And no matter the personal intention of the arbitrator, I believe that such conduct does not seem right from the outside perspective. And this overall rather brings a bad image to investment arbitration. To counter that, I have been participating at the Ancestral Working Group, and last year we have adopted this new code of conduct for arbitrators in investment cases, which now does prohibit concurrent double-hatting and restricts quite a bit the subsequent double-hatting. However, the problem with this is that there is, at least for now, there's no any like binding enforcement mechanism for this code. And Czech Republic being the EU member state, particularly the EU and the Commission believes that this perceived lack of independence in investment cases can only be remedied by creating a permanent investment court with judges nominated by the state. Another major downside of the investment arbitration is the lack of consistency of the awards. Because consistency brings predictability for both states and investors. And thus, it also enhances the legitimacy of the whole system. But it's really not a feature built into the current ISDS system, which is formed by investment tribunals constituted ad hoc for each case. And there is no hierarchic structure which would harmonize the case law over divisive issues. And when you look at the current review mechanism in arbitration, it really focuses on integrity and fairness of the process. And the consistency is not really the main objective here. And this is not surprising because the whole ISDS system, investment arbitration, it's based on the same structure as commercial arbitration, where really consistency is not that much of an issue. But in investment cases, these inconsistent decisions do happen, and I can, again, just briefly mention two examples from the Czech Republic experiences. We had, for example, these two cases which were initiated by the ultimate owner, the American billionaire Ronald Lauder, and his company CME. And these cases were based on completely same facts, the same measures. But the result was completely opposite. In the Lauder case, all the claims were dismissed. We didn't have to pay anything. But then only 10 days later, the majority in the CME case, they made the Czech Republic pay like $330 million, which it's an old case, it was 2001. But at that time, for example, this award was the same as the whole budget of our Ministry of Health for the whole year. So it created quite a wave. And to give you a second example, I mentioned these solar cases against the Czech Republic. We had seven of them, 6 we won, but then in one case, the tribunal found a breach of FAT. Again, the measures all was the same. So what to do about that? I think that perhaps, at least for investment arbitration and some form of appellate mechanism, or even this permanent investment court could be a solution, because one could expect that the permanent judges deciding cases over time would strive towards delivering more consistent decisions, and they could resolve these issues which divide the investment tribunals these days. So I think that such a reform could really bring more certainty, even though, of course, you would need to accept that it might increase perhaps the length and the cost of the proceedings. But given that even nowadays, almost in every investment case I see, one of the side goes to exit annulment, I believe that if we would make it an appeal, it would not add that much. Of course, whether this reform will be accepted by UNCITRAL, we'll have to see. So to conclude, I think that it might be useful to say a few words on costs, as this, from a client perspective, is of course always a very delicate topic. So just to give you an idea, according to this 2021 study, average legal costs in investment arbitration are for investor $6.4 million and for a state $4.7 million. To tackle the soaring costs, I have built a dedicated internal team while still hiring external counsel. And in practice, we are now highly involved in the preparation of the submissions and the hearings. And in combination with appropriate tender procedures, this helped us to significantly decrease our legal costs. And to illustrate the impact, I can say that our average legal costs for the first 16 investment arbitrations, which were run between 1999 and 2012, were $4.5 million per case, compared to the average cost of the last 15 arbitration cases, which were run between 2017 and 2023. So at the time when I was at the ministry, the average cost per case is $2 million per case. So we went to more than two times less. And by this, I want to show that I think as a client, you can try to change your approach to achieve major cost savings, while at the same time try to keep the quality very high. Now, my final point would be a critical appraisal of the application of the costs follow the event rule. From the 15 investment cases that I have worked on in the past 7 years, we have lost 2 cases, and in these 2 cases, the claimants were awarded respectively 30% and 15% of the claimed damages. But at the same time, even though you can say that they were not that successful, the tribunal still awarded them 70% of the cost in one case and the 75% of the cost in the second case. And I believe that the awarded costs should take much more into account to what extent the claimants were actually successful in terms of damages. Because in my experience, claimants often inflate damages in investment arbitrations, which on its own creates a lot of extra work and the associated costs to deal with their submissions. Thank you.
Thank you so much, Jarek. It's very interesting to hear the perspective not only of the client, but also of a governmental client. I know that you must face some budgetary restrictions and controls that sometimes in companies we do not see. So now, Sajan, what are your views? Pros and cons.
I think it's good we settled. His winning ratio is pretty high.
Yeah.
He's saying 31 out of 39. Anyways, thank you for having me here. I think it's a pleasure to be part of this event. I think from our perspective, what are the pros of arbitration? I'm assuming that all of us here in the room have basic knowledge or maybe an advanced knowledge of arbitration, that we know about the costs and other things. When it comes to a large organization like us, where do we use arbitration, and where do we find it much more impactful than the traditional litigation? I think one of the factors which really plays for us is the independence of the courts, and we operate across the globe, and the independence of court, or in other words, rule of law, may differ from jurisdiction to jurisdiction. And the moment you put it in local courts, that play a very, very important part if you are arbitrating against the government. And if government is a counterparty, normally there will be questions of revenue which could hit the state exchequer, and you may feel that the courts are not very independent. And it doesn't mean they are dishonest, but they may be influenced by the various opinions which are going. And in those cases, certainly we prefer arbitration. And VIII has been a big advantage for us. It has also led to a number of countries coming and sitting down with us and doing the settlement. Because VIIT is drafted in a way that it really takes care of the interest of the investors with very few exceptions. And wherever we have a VIIT, it has really helped us in bringing our disputes down. We had huge settlements. When it comes to commercial parties, and we have a lot of those disputes with our companies from whom we buy. We on an average, our revenue is about $60 billion a year, which means that we are one of the biggest buyer of coal, iron ore, gas across the world, and we have those contracts. And in those contracts, we prefer arbitration. One, it is faster. And second, the experts really help. Whichever country you go, leave aside some specific jurisdiction like corporate law in Delaware or some commercial courts in UK. It is very, very difficult to find judges who are experts in particular field. And for a company like us, you normally end up having these disagreements with people whom you will continue to deal with. It's not that it's a one transaction and then you have a disagreement and they go to their home and you go to yours. You keep on doing continuous transactions. So parties actually don't want to litigate for years. They want to sit down, sort out that specific issues and move on. And that's where arbitration and sometimes mediation comes quite handy. And the third is the choice of law is much easier, and institutional arbitration is always preferred over ad hoc because of the rules and the procedures and the appointment of arbitrators, the availability of the panel. A lot of confusion. You say, oh, go to ICSID, go to ICC, go to SIAC, go to Dubai. You are doing some work in China. They will say, okay, go to Hong Kong. Now you have Riyadh coming up. So everyone has their own sort of preferences. We try to stick to London or New York. And for South Asia, we try and stick to SIAC. So that has an advantage as compared to courts. And if you go to the cons, I think the biggest issue we are seeing is how much work arbitrators are doing. This concept of tribunal secretary, where are they stopping? Is their job is to take the notings, do the procedural hearing, or even go to the in fact of writing down the judgments. So are the arbitrators actually spending time and using their knowledge to do it? I didn't attend the last panel, but I think it was on corruption. And corruption maybe in that Nigerian case may be a word. It's probably a strong word, but there are a lot of influences which happens. And in three arbitrators, you will always end up saying my arbitrator, my arbitrator. At the end of the day, you nominate the arbitrator. It's not your arbitrator. And then it comes down to the point that, okay, there are two arbitrators. Everything will come down to the chair because my arbitrator will decide for me and their arbitrator will decide for them. So chair should be important. And a couple of weeks ago, I attended a very large arbitration in Sao Paulo. And that was my first time in Sao Paulo. Very big arbitration. One of the biggest private arbitration in Sao Paulo. And we had 30 lawyers. It's pretty big on one side. This was this big a conference room, 30 lawyers on this side, 30 lawyers on this side with these three arbitrators. And at the end of each session, my team of lawyers is like, okay, the arbitrator was listening to this point, note it down. He was doing this, let's note it down. So there is so much reaction and everything is happening. So arbitrator, and when say you go back to India, the market is the arbitration market is led by the retired judges of the Supreme Court of India, which is the highest court, and 90% of cases you will find them doing it. Now that goes against the basic principle that you need to have experts. These are very good jurists. They know the law, but they are not the experts. They have either done broad civil law or they have done broad commercial law, but they are not expert. And then the market is in such a way that very few private practitioners who are there who are really contributing to it. So corruption may not be the right word, but the appointment of arbitrators needs to be maybe done slightly better than it is being done currently. And another issue which we faced, and I am speaking from practical experience, I don't do arbitration day in, day out as Chaslav does. In one of my arbitration, an expert said, I have some personal commitment and I am leaving. And arbitration was going on. And so we said, what's the personal commitment? Also, it's confidential. I was like, okay, you have to depose for me on Monday, and it's Thursday. What should I do? And we have been preparing for 2.5 years. And after a lot of pullback and stuff, she agreed that she will come on Monday morning and depose. She came, she deposed, which according to us could have gone better. But it raised a question for me, is that where do you go and complain about their behavior? There is no agency, there is no authority. The best I could do is to maybe blacklist the firm she represented. And that's it. There is no bar, there is no arbitrant like ICC or an institution that where you say that, look, this arbitrator did this with us. And the lawyers are advising that, oh, we may have to make a written submission after the hearing, so please don't say anything to her. She's our expert. We have to be nice to her. It's everything done. So that's one of the practical learnings I had is that you need people with accountability. You know? And how much accountability the experts have, how much accountability the arbitrators have. Arbitrators have a lot of immunity, and that's why they are there and they can freely take the decision. And the last point I will make about the cons of arbitration is enforcement. I have so many awards, but I don't have the money. You keep on chasing. You go on one location to other location. You don't find the assets. Then you need judgment. Then you need the New York Convention. So at the end of the day, for an enterprise like me, even if we now make 2 columns: arbitration 1, X amount; arbitration likely to receive money is a Y amount. So it's really not turning into an actual dollar in a number of cases, which remains a huge concern for us. And some of the countries, and I think someone even spoke about Indian arbitration, the Kane judgment, where Indian government ended up paying later, and there was stays by the local court, which was very unfortunate that happened in India. But you have a number of countries who have not honored their enforcement awards, and the global community has not done much about that. And then the private parties, it's very difficult to find the assets as long as you have these so-called tax-haven jurisdictions and things are built around that. So that's a big problem for the arbitral awards, that the enforcement is an issue.
Thank you so much, Sapan. It's great to hear such an extensive and worldwide experience. I have many questions about what you said, but at first, of course, we should listen to Catherine Young from Shell, your experience on pros and cons of arbitration.
Yes, lots to say, and thank you. It's a pleasure to be here. It's always a treat to have to sit under a photograph of yourself taken 13 years ago, so good reminder to update the LinkedIn photo. And I should also copy Jarek and just confirm that obviously everything I will share is very much my own personal view. It's not the view of Shell. I enjoyed in the previous panel, I think there was a bit of a debate between a litigator and an arbitrator, and that was a nice thing to see. I actually happily get to do litigation and arbitration. I've been with Shell for 2 years. I sit in the global litigation team. On my desk at any one time, everything from an issue with the business over a few $100,000 to something in the multiple billions. So really exciting mix of work. Pros and cons of arbitration. I mean, happily, we didn't actually compare notes, and I don't think there's much overlap, so I won't touch on what my colleagues have already said, but it was great to hear from you. I think the key thing that I like, and this is going on practical recent experience of what works really well for us in arbitration, is, I guess, the flexibility and the opportunity that the tribunal have, if they're really engaged, to design a really bespoke process that's going to be really just the best thing for this specific case. Because ultimately, we're representing a business. The business doesn't want to be in dispute all the time. They want to just be getting on with things. They're all lovely, but they'd rather really not be talking to me all the time. So where the tribunal can actually make those good decisions at an early stage, whether it's bifurcation or other things, that helps us get to the nub of the dispute quickly and early. I think that's where arbitration has real value. Moving on to my dislikes or the cons, I'll be as candid as possible. Often it takes too long. Often it's too expensive. I don't think those are surprising things to hear from a client. But I think one of the key bugbears really that I have is, I guess, a lack of sort of firmness of grip on the procedure that you sometimes experience from the tribunal. And that can be really, really frustrating. Obviously, we're engaged in certain arbitrations where there's two commercial parties, everybody just wants to get on with it and get back to business, and it runs very smoothly. But of course, we come up against all kinds of different counterparties, and where you're opposite a recalcitrant counterparty, and the tribunal aren't really getting on top of that, it's very difficult. And obviously, we're the clients of the external counsel, but I have my own clients internally, business stakeholders who it might be their first arbitration, they may have never been involved in a dispute before, and they're literally saying to me, Katie, why is this happening? Why is the tribunal allowing this to happen? What can we do about it? We thought we trusted them. We thought you chose a good panel. So just to give a recent example, again, something sort of seemingly minor, procedural, but we had a procedural hearing, quite a long one, days, not hours, and we were very happy with the result, and we then obviously go forward, we live by the procedural order that's come out of that hearing. Roll forward, several months, and obviously we've done what we can to comply with it to the letter. The counterparty, we feel, hasn't complied, hasn't even tried. And, of course, we write to the tribunal and say, look, this is clearly not okay. And then my internal client is saying to me, what's going to happen? Now, as lawyers, of course, we're all used to explaining litigation risk, but really the clients just want to know what's going to happen next. Give me, you can't tell me exactly, but give me within a range, what are the options, what's most likely to happen. And unfortunately, in this particular instance, we said, well, really they should tell them to do their homework and behave and give them a little bit of extra time, and then hopefully we'll all move on. But unfortunately, this particular incident took us multiple letters, several weeks, a further hearing to resolve, because I think we counted there were probably 4 attempts to basically circumvent the procedure that we felt had been agreed, some months before. And really, the damage, the sort of ripple effect from what we felt was sort of poor engagement from the tribunal in dealing with this particular incident, getting on top of it, it costs more because we have to engage in lots of follow-up, lots of new calls, letters, a further hearing before we got everything sort of back on track. And it really erodes the trust, sort of partially with us as the lawyers, but also for the internal client. They're now, they're then sort of wobbling and saying, did you pick the right panel? Have we got the right panel in place? So, it's very disappointing to see that happen, but unfortunately it does happen. And so, you can almost see when you're seeing the emails come back from the tribunal with these kind of perhaps not quite what you would like to be reading, you can almost see the kind of due process watermark on the page, because that seems to be obviously what's concerning them and driving that behaviour. But more courage, I think, from the arbitrators is what we're looking for in that scenario.
Okay. Thank you, Katie. And as you mentioned, the question of costs, I'll start making you a question that I think that every lawyer, external lawyer, would have to hear the answer. Mm-hmm. Which are your preferred and least preferred structures of fees?
Yeah, great question. Happy to answer. I've also, Shell has a particular way of trying to structure fees with external counsel. In my Norton Rose Fulbright days, I was on the other side of that. I worked for them before going in-house. So I've lived through the pain of trying to agree the fees, and obviously now I'm on the other side of it. Effectively, what we're keen to do, and this is an unpopular thing to say, is move away to the extent possible from just the hourly billing. Because really what we want to be doing is agreeing a price for a certain piece of work that we feel is good value for what's going to be done and for the product. And obviously, it's difficult because, law firms and counsel, they all bill on an hourly basis. But what we do wherever possible is try to agree capped fees for certain phases of work, and it really is possible if the law firm or the counsel are willing to engage with that. And it's also, nobody's trying to be unfair to anyone. So we're not trying to say at the start of the matter, the fee cap is X and we'll never revisit that. I've certainly, when I was on the law firm side, I've agreed capped fees and different phases. And as long as it's supported by, some detailed assumptions, it's then perfectly possible to go back and have the conversation and say, well, things have changed, this has taken longer, or there are more documents to look at, or we've got more witnesses, or something has changed. And it's a sensible conversation. We're not looking to be unfair to anybody. But I have to say, it's not always, it doesn't always get good engagement from law firms and counsel. The worst offenders, I guess, are the ones where they come to us after the work is done and say, we spent twice as much.
But if during the arbitral proceedings, the law firm raises a red flag and says, we are spending twice as much as we thought.
Exactly, that's what we're looking for, right? So my message really would be just to be proactive. So it's always much, and the reason we try and put in place fee caps is because ultimately the business wants some certainty around costs. It's always perfectly possible for us to go back and have another conversation. Everybody is reasonable, but it becomes a lot more difficult if we're only being told after the event. I know that these mythical creatures called legal project managers exist in law firms. I'm sure I remember them from my Norton Rose days, and I know they're around. And of course, having done the job myself, we understand what it's like. Late nights, working to deadlines. But there's really got to be discipline around the time recording so that snapshot at any one time that the partner might say, right, I'm going to check on the budget so that is accurate. And then the conversation can happen at the right time, basically, because it's much more difficult for me to go to my business stakeholder 2 months after the event and say, oh, do you remember that time when we were working really hard? I'm going to need some more budget for that.
Yeah, I see.
Can I come in here, Gabriel?
Yes, of course.
So I think it's a big cost issue. For us, it starts from day zero, because you will see these business leaders across the globe. Oh, I have to sue this person. He has done this with me. He has done that with me. And now you have to explain to him that, okay, business and emotions are fine, but it's going to cost you an X million $. Are you okay? So the conversation has to start from day one that before you start the litigation or an arbitration, are you ready enough? Because once you take a position, there is no going back, unless there's a settlement and all. So the business guys need to understand that from very beginning, so that the budgets can be managed. The second thing, the billable hours is probably the most spoken or most cruel things which has lasted for so long. And it continues to last. It continues to carry on. With all the AI, we have so many companies coming in pitching for software that we can check and we can do all of that. But it just stays there. I think what we are trying to do, some cases we have been successful, is to do alternative fee arrangements where a number of US law firms were open. Some are quite open, taking a lot of risk. Some are willing to do it at a lower cost, but an upside on the result. More and more UK firms are now joining that discussion. That gives us a little bit of control on surprises, because those sort of fee arrangements don't allow increase in any cost while the arbitrations are going on, because they say, okay, we will take the next amount for each stage. That's completely capped. If we win or lose, this is how we are going to get paid. So you have a fixed cost, and and it's easier with the business guys and the budgeting to get it done. And the third is the litigation funding is really changing the structure. We as a company are not using it, but a lot of companies are using litigation funding to fund their arbitrations, and they are coming up with very fancy structures for a number of organizations, and they are getting more and more entrenched with law firms. And the fourth is, I think all of us talk about AI, how AI is going to impact arbitration. It has started helping us in billing. Because when you go back, you will look at the bill. Someone will have to go, say 5 years ago, 7 years ago, and they look at the entry and then say, oh, one letter has been drafted by 4 associates. Yeah. And then you go back, and then emails will keep on going back and forth for months, and someone will get tired and give it up and say, okay, let's settle it and finish it. And then people will also start questioning each other's judgment that, oh, this letter took time, this agreement took time, how do you know it can be done in 2 hours? Now there are softwares available in market who can actually just feed the bill, and it can quickly show you what are the duplicate entries, what are at the same time that on the same letter there are 5 people who are working. So there's a lot of data which law firms cannot counter, because that has been checked by technology, and it goes back to you and say, guys, this is the problem. And they don't really argue on that much, because they don't have any. The human element is gone out of it, and therefore the fees invoice correction discussions are much faster and better. So AI is playing a bit of a role in the billable hour scenario.
And I just wanted to pick up on one thing you said there, talking about certain firms being open to a cap and then maybe an upside, obviously in a success scenario. And there's obviously a bit of work that you have to do to define what is success for this particular case, etc. But I think we certainly, as clients, like seeing those sorts of arrangements where you feel the law firm have got some skin in the game as well. So we're very open to creative suggestions. And it
does take time, because you are right, and it becomes much more difficult when you are defending. Yeah. Because you say, okay, you have a claim against you for $100. Now you have to pay 50 instead of 100. Now what is the success? So we have done it the other way. Say if we have to pay $25, then you have saved 75 for us. That what percentage of that we will pay you? There is no element of procedural that you will get my arbitrator in, you will get my venue in. All of that goes on real cost. So you can actually look at the final hearings or the final results, not the procedural things. But it works out, because there's a bit of an upside for the law firms, and then a stability for us. Because the worst part is that you want to have conversation with your CFOs at the end of the year that I estimated $100 and the cost is 160, 170. Because it raises questions on that, okay, how well were you managing it? Were you watching the law firm? How are your relationships? So the budgeting is a big key for in-house people, especially in difficult environments. Yeah.
Well, if I can just add to that, I think from a state perspective, there is one additional element that when we pay the law firms is public money.
Ours is public too, shareholders.
So I think the law firms sometimes have a harder time to understand that we have a little bit less flexibility. That in a way, when we choose the law firm, we for example do 50% monthly caps, 50% hourly rates, and you put your numbers, you win. But because we do a tender for that, then we cannot just touch that, because if you won the tender on the price, you cannot come next month and say oh, well, it'll be 3 times more, and you still want to have the contract. So you really need to do this estimate well, because you will be stuck with that for the rest of the case. And I really like, Sapan, your comment about the AI checking the invoices, because I have to say, in my 10-member team, I have 8 lawyers, and I have 2 people who are checking the invoices for
we have stopped
exactly
doing
that.
We can talk about it. It really helped.
Yeah.
Because what happens is that the in-house lawyer and the partner are fighting, let's use a stronger word, and they won't sort it out because the lawyer doesn't want less money. And then after 3 months, they will come to your table and they want to do a video call and showing you entries that, oh, this is going through. Now, how the hell you know that how much time an associate took to draft an agreement 6 months ago? You know? So you are just looking at who is sounding more reasonable. So it becomes very difficult. But to your point, then there may be firms who don't tender, because there are firms who don't want to do work at a. So do you feel that you get a lesser choice, or you feel that there are enough firms who take interest?
No, I think it's, I think at least in investment arbitration, but in arbitration in general, what I see is this trend of we have more and more arbitration boutiques, kind of this move from the traditional, like the big, just US Anglo-Saxon firms, which were really dominating the markets, let's say 20 years ago, that now I see there's many more, like, Paris and London, like these arbitration boutiques, and the way they are structured, they are able to be much more competitive. So they are still like very happy to go after these investment cases, because it's still they might get a little bit, the fees are maybe smaller, but these investment cases, as you know, they last very long.
There's a lot of prestige in representing government.
They make the math.
I think you're right. It's about having the conversation and getting it right at the beginning, because there's nothing more frustrating than, obviously we always look at a range of firms before we decide who we might instruct on a big case. And sometimes the firm can eliminate themselves because they've so obviously tried to lowball it to get the instruction, and it's just so way off the mark that we just go, well, that's just completely unrealistic. So we're going to look at these 2 who are actually quoting us something that sounds sensible. So
yes,
yeah.
Now, let me turn a little bit the scope of our conversation, and let take a look at the lawyers. Jarek, do you see a gap between the quality of work of lawyers from different countries?
It's a hard question, because I don't want to discriminate against everyone. But perhaps as an introduction, in my cases, for example, right now I work with lawyers from DC, New York, London, Paris, Frankfurt, and Vienna, like all in arbitration. So I think I have a relatively broad overview, and I think my general sense is that I think that this gap among arbitration lawyers has been decreasing overall. And I say so because when I compare, let's say, the time when I was inviting case in New York 15 years ago, I really felt that at least the investment arbitration world, it was really dominated by like Whiting Case, Freshfield, Sherman Sterling. There was these few big Anglo-Saxon firms, and like all the clients were just coming in because everyone just thought like, oh, these are the only firms which have the capacity, the knowledge, the experience to handle that. And I really think that, generally speaking, this period, like this has come to an end. And I think one manifestation is what I mentioned is, for example, these arbitration boutiques, which we have seen, I think, more and more, especially in recent years. And they are both in these arbitration centers, like London, Paris, but now even beyond. And I think another point is that I think we have now more, I would say, lawyers qualified in arbitrations than 15 years ago. So I think that the gap has narrowed, but at the same time, I think as a client, you still need to be very cautious and smart when choosing your counsel, because I think we also see there is many more people who are saying that they are like experts in arbitration. But in a way, I think that you really need to see like how much work they did, like how much they really know. And we ourselves, we try to, when we do like these pre-selections of which law firms we choose for a tender for a particular case, we really do it like, not like these general panels, but we really do like case by case. Like we look, this case, like how complex we think it will be, like, who the investor picked. Did they pick like King & Spalding, like a big American firm or not? How much money is at stake? And based on that, we really try to choose whether we can go for, let's say, even like a smaller boutique, let's say even in Germany or Vienna, which can compete much more on price, or whether we want to put like a bigger budget and go for someone, let's say, more established. I think for example, some like small or medium investment cases, like nowadays you can on price like get very good results with these arbitration boutiques, because they can still do the quality of work, which is more than enough for those matters at hand.
Good. And Sapan, you mentioned that in India, the arbitrators market is dominated by retired judges. Which are the criteria that you use to choose an arbitrator or to discuss with external lawyer the choice of an arbitrator?
I think the law is the most important part, because we have number of arbitration which are local law, local country law. Say if we are in France, we will have French law. So the first thing will start from the people who have the knowledge or expertise on that particular law. Second comes the expert or the experience they have in say oil and gas, mining, government disputes. Third, which plays a very important role, is the recommendation of our counsel. Because they are doing much more arbitration, they are in the place and they are able to say that, okay, what sort of an arbitrator will work. And we normally end up asking them to give us 3 to 5 choices. We agree on criteria which is around the law, the expertise, the independence, availability, and if we are looking for some specific interim things, that whether they are keen or they are okay to do that. Sometimes even things like whether they are willing to do virtual arbitration compared to physical arbitration. And post that discussion, we do our metrics based on the law firm's recommendation, and then we select. Costs are in arbitrator. That's the last element for us, because the quality is very, very important. And then there are the standard checks like conflict. And unless there are direct conflicts or conflict under the IBA rules and all, we don't make a big deal about it as a company. Because what we have seen is that maybe live in London or New York, the availability of quality arbitrator is not very huge. So once you have shortlisted few people, then you used to have a lighter hand in striking them down. If someone comes and say, oh, the opposite party was his client 20 years ago, we don't see it as, we wouldn't want to see it as a conflict under the IBA rules, says that. Because we believe that quality is important, and people are independent, and if they have the reputation of being independent, that's the key aspect. And in almost all jurisdiction, you can't approach the arbitrators once they are appointed. So it's more in your minds that okay, you have it and you can do it, rather than being effectively able to do anything. So I think those are the criteria we follow in selecting the arbitrator. But I would say that as more and more I'm talking about it, our external counsel play a very, very important role in selecting.
Can I just...
Yes, of course.
No, you ask.
Actually, you said something, among other things, that is especially interesting, that you choose an arbitrator that has knowledge of the applicable law. Even if it is international arbitration, you take a look at the substantive law to be applied and use these as criterion. So typically, for example, in an arbitration involving Brazilian law, you would choose a Brazilian arbitrator or someone qualified in Brazilian law.
Mostly, but say if you go to a West African country, you know, now a lot of these countries follow French law.
Okay.
So you may end up having an arbitrator who has great knowledge of French law. But so those sort of things are there. Recently, we have started getting requests that we say, like we had a big Indian arbitration. There are a lot of arbitrators who were not qualified in India approached us that they want to arbitrate. You know. Now that depends on jurisdiction. India has its own arbitrator which can manage. But say if it is happening in a West African country where the local pool is not there, then you will end up having someone, and you will normally find these arbitrators or barristers in UK or in Paris who will have this sort of experience.
Sorry, Katie.
No need to apologise. I would very much echo everything Sapan said in terms of the criteria that we work through. It's a sort of very detailed process we go through when we're selecting a candidate to nominate. But there's one additional criteria which I'm going to put my ERA hat on. I sit on the Equal Representation Arbitration Pledge Corporate Subcommittee. So we do also factor that in when we're selecting candidates. DE&I is very much at the core of everything we do. So I think most of my colleagues, if we were to be sent a shortlist of 6, we normally look at 5 or 6 names as well, with no diversity, no female name on there, we would probably send it back and say, could you have another look, please? And that's not to say that is the main factor we look at or the driving force, but we like to factor it in and make a point of doing that. And it's something that gets factored into the mix.
And there are many research showing that if you have a diverse group, the decision will be better.
Yeah. Well, look at the diverse panel that we have. It's great to see, diversity in the audience. And, if you'll indulge me, on a personal level, my mum had a fantastic career, was more successful than my father, was earning more when she stopped to have children. But then she worked in the fashion industry. It wasn't easy in the 80s to get back into it. So, she was a stay-at-home mum, whereas my partner's at home looking after my 4-year-old today while mummy's at the conference. So I think things have already changed a lot, but I like the fact that she's 4 and it's normal for mummy to have gone on a work trip. So I think, the more we can do, the better.
Yes.
And perhaps just to say, as I'm in the investment arbitration world, there is still a lot to do.
More to do.
I just saw as you just mentioned, I saw the recent statistic in investment arbitration for arbitrators. It's all cases until now, it's 15% women to 85% of men. Ooh. And then also the tricky thing, from the 15% of the arbitrations which went to women's arbitrator, 60% of that are Bridget Stern and Gabrielle Kaufman-Kohler. So half of the women's appointment are two women. So,
but I totally agree with what you said, Gabrielle, that, obviously we think, our brains work in different ways, we think differently. Yeah. So having that range of views is great and results in kind of good decisions, but ultimately, we've got to be in the room first.
So, Sapan, when we were preparing for this panel, we talked a lot about cultural differences. Having this broad experience worldwide, how do you think cultural differences affect the practice of arbitration?
I think it does by a huge margin, because there are many jurisdictions across the world which still don't prefer arbitration. And there is a bit of a tug war because the judiciary feels that arbitration will take over the court activity. And the commercial matters, especially in the developing world, are now the center stage. Therefore, for the importance of the judiciary and the practicing judges, the arbitration is not the best mode of sorting it out because they see it as a challenge to their power. What it does is that it leads to interference. So you have orders getting challenged, you have enforcement being challenged, you have delays in appointment of arbitrator if the issue goes to courts. So has arbitration been accepted by the entire world? I think the answer is no, according to me. Enforcement is a result of that because you have to take the award in multi-jurisdiction awards to the other jurisdictions, where mostly you will have to go through the courts, and courts can straight away go and acknowledge those awards, like what they do in UK mostly, but in many countries they don't. Sometimes they even go into the merits. Sometimes they even go into the public policy, which is exception to most of the arbitration acts across the globe. I think there's a lot to catch up if you have to see across the globe. But whether it is increasing, the answer is yes, it is increasing. In some countries, it has also been raised as an issue that arbitration breeds more corruption than the judiciary, which has slowed down the progress of arbitration. But I think there is a lot of stress, stress on saying that arbitration is here to stay. With all these dispute weeks, with the practitioners coming across the world, the law firms developing their practices on arbitration, some of the successes in VIITs. So yes, cultural difference is there. Whether arbitration is there to stay, I think the answer is yes. It is just past that stage where it is still being considered as an efficacy. It is there, it is acknowledged in most of the countries. Only the strength differs, that how much powerful, forceful it is.
Katie, I'm sure everyone here would love to hear your experience on this too, as you are an in-house counsel for such a big group.
Yeah, the cultural differences. I was thinking actually, I agree with what Sapan was saying, but I see them manifest in another way as well, which is, obviously I've trained in London and I trained at Norton Rose Fulbright. It's not known to be a particularly overly aggressive firm. There are some firms out there that are perhaps have that reputation. But it can happen where, we work sort of hand in glove with the business, on our cases and involve them as much as we can in the decision making. And that can even come down to how we're going to plead a particular point, and where the cultural differences can come in is sometimes the business effectively wanting to pull us back slightly from what they see as, what I might see as that's completely normal, it's just a robust argument, it's not overly aggressive, and they're going, oh, okay, can you dial that down please, because we have an ongoing relationship with the counterparty. We're trying to work together day to day. And if you write that, we'll just get pulled into a meeting next week, and that will be topic number one on the agenda. So I think the cultural differences can come in that sense, is what I'm seeing a lot at the moment.
Can I just quickly, in investment arbitration, you feel like it should be more like uniform, like harmonized international arbitration, but I can still, where I see these cultural differences come in is that, for example, now on a lot of my cases, like you mentioned the former India Supreme Court judges. Well, in investment arbitration, I now see more often the UK former Supreme Court judges, particularly for the chair, because as you know, for investment arbitration, to get your candidates, you really check all the cases, all the decisions they did. When you're choosing your arbitrator, but for the chair, it's sometimes really hard to agree on someone. And on my one recent case with the other side, for the investor, we exchanged like 24 names, and we finally settled on a recently retired UK Supreme Court judge who had like 4 pending cases, so no decision yet, so no one knew what was he thinking. But that was interesting then to see the consequences when you choose someone like that as a chair in this like investment arbitration, because they spend their whole life in your UK litigation system. So they kind of bring that in the little things. It's like, I was like, before the hearing, they just want like, oh, like, can you just throw these extra skeleton arguments, which in normal international arbitration, we don't do that. Or like how they see the admissibility, like some procedural rulings that they could really see that they were stricter, I would say, than some civil law, because in the UK litigation is a little bit more on point. So I think it's important to really know the background of your arbitrators, because it can play a role how they will perceive the proceedings.
So you see, when you have, especially a chairperson of the tribunal that is a former judge, you see a tendency to make the arbitral proceedings more similar to judiciary proceedings?
I mean, I think they definitely do bring their package with them. Especially they just got this in arbitration as this gig for retirement, so I mean their influence. You have to just hope that you have usually like the co-arbitrators who are like more seasoned, so we kind of hope that they will kind of balance it out. Yeah.
Now, Katie, let me ask you a point-blank question.
Sure.
Are you satisfied with the quality of arbitrators' work?
I think the honest answer is yes and no. It depends. We obviously see some fantastic tribunals and really engaged arbitrators and some really good decisions. But, I have recently sat through a final hearing where the chair had no questions at all. And I just found that completely baffling. Maybe it's because our case was just so compellingly brilliant that we won, and there's just he had no questions for that reason. But that can be difficult because obviously, like Sapan was talking about, the team in your very big case with the 30 lawyers, and everyone's taking notes on what questions the arbitrator asked or what's he written down, and go back internally, and the client's saying to me, well, what do you think? What questions did they ask? So that's quite a difficult conversation when you have to go back and say, he asked no questions at all. They asked no questions at all. What else? I alluded to it at the beginning in my kind of pros and cons. The cons being, where there's sort of we perceive a lack of kind of immediate firm grip on the procedure and kind of sticking with what we all feel we've agreed and what we've been working to. Sort of that frustration. I would say not in my personal experience, but I'm involved in lots of disputes where we're perhaps part of a JV, so it's not just Shell and our external lawyers who are involved in selecting the person we might nominate. I'm talking to not necessarily Sapan, but colleagues from other companies as well. So you pick up little bits of feedback from them as well, which is really invaluable. I kind of store it away in my notebook of feedback on arbitrators. And for example, I was really pushing a candidate recently saying, I think they'd be exactly right for this case. I've had a really good decision from them in the past, and these are all my reasons. And I was really having pushback and disagreement from a colleague from another company who was just saying, well, what I'm hearing internally is that, that person had their juniors write the award and weren't engaged enough. So, ultimately, I managed to persuade this colleague that we should include that name on the list. But those are the sorts of complaints that you do get to hear about.
What about you?
It really depends on the result. But I think generally we are fine with the selection of the arbitrators overall. As I said, that some jurisdiction we have a problem of very limited pool and a limited similar set of experience. That's a bit of a problem in a few countries, but other than that we are satisfied. And we may have to, we increasingly think that in those jurisdictions should we take the lead and start appointing arbitrators outside that jurisdiction. And I believe that multinational companies will have to probably take a lead in that and say that even if it's an Indian law arbitration, we will appoint an arbitrator who is not an Indian law expert, but is sitting outside and who knows arbitration, or an Indian law expert who never practiced in India, so that there is more. But I think it will have to come through the clients, it will have to come through multinational companies like us who have seen both sides. and I think it will happen sooner than later as the market is growing.
Well, if I can have a complaint, I mean, of course, as I think as Kate said, it depends. But what I see, at least in investment arbitration, that I see sometimes, especially for chairs, that there are like some arbitrators who take on too many cases, like more than they can handle, and as a result, like the average time to get the award in my cases is like from the last, like the hearing or the last like post-hearing brief is like 1.5 years as the average, and it's just like a really long time. And then the worst is when you wait like 1.5 or 2 years, and you mentioned the tribunal secretaries, and often like we have like 300-page award, but let's say 70 or 75% of the award is like done by the secretaries, kind of like summarizing, right?
The reports.
Like all the arguments of the parties, and then from the tribunal, I have like always like on every issue, sometimes like this really big issue, novel issue, and they just put like these 2 or 3 little paragraphs on reasoning and like this like that after like 20 pages of summarizing the arguments, and it's a little bit disappointing.
So you need a good tribunal secretary with a good arbitrator.
Well, yeah. So I think because there's a big complaint at least in investment arbitration, the length of the proceedings. But when then you look into the actual schedule, like now for pleadings, it's often like 3 months for each pleading, which in investment arbitration, it's actually like a little short time for that. But most of the time comes from just waiting for the award.
Yeah. Let me ask you a question that I was discussing with my dear friend, André Monteiro. Do you think that arbitral institutions should deny the confirmation of arbitrators for excessive workload?
I mean, I would hope that the arbitrator himself or herself would be enough reasonable to kind of assess that. I'm not sure about that. I mean, what we have seen, like for example, in the new exit rules, that now they put in these express provisions that the institution can cut, and I think ICC have now that too, right? They can cut your fees if you take too long. Yeah. I think it might be a way to go if the institutions are bold enough to actually use it. Yeah.
We do talk about it though when we're as another kind of factor when we're looking at who to appoint. There are certain names who are known to kind of not take on too much and not overload themselves. So that's something that appears on the list, or on the list of kind of pros under a certain name.
And just one last question before we we have our audience making them. I'd like to raise maybe the hottest topic in Brazil nowadays, which is the duty of disclosure of arbitrators and conflicts of interests. Do you think, Jarek, that the duty of disclosure has been properly complied with in the cases, of course, you worked? Or have you seen some surprises during the proceedings?
Well, I think there are still some limits. I mean, I think it's improving, but for example, I think the problem is in the past, like this, the whole like double hatting, it was not taken seriously enough. So the lawyers sometimes did not, like the lawyers / arbitrators did not like disclose that, and it came up much later. And it makes me really think about this point Sapan made about that arbitrators are actually not accountable because they have all these immunities, so you cannot do anything. Like to give you one example, that when the ACMEA, which we heard a lot about this morning, when that came out, like in like 3 cases we had, like all the arbitrators who were also the partners in the law firms, they suddenly like resigned because they did not want to be as an arbitrator like deciding on this issue, because their firms had mandates for clients, which they bring them more money, right? So they didn't want to kind of decide that as an arbitrator. But in our cases, and sometimes caused like really huge delays and a lot of costs. When you have these guys like resign, and let's say before the hearing, or even after hearing, but before the award, and there's like nothing you can do really. Like you cannot sue them to get money, like they still get paid. And yeah, I think it's a
But
it's
I
issue,
think in today's age, there's a lot of public information available. So the duty of disclosure, I think the arbitrators take it very seriously. And as a process, I think the external counsel also do their own search when they recommend. So it's always advisable that your law firm is also doing their own sort of inquiry and searches before when the arbitrator names are put in. And normally we see that they would have already done it, and they end up asking questions before the appointment. Like, but we saw this. What this case affect your appointment here, and then they answer. And if they answer it in a satisfactory way, you go ahead. So with the Google and information and databases, I think it's very hard to conceal all this, and arbitrators realize that.
Yeah, I totally agree. In my experience, I see that not only the duty of disclosure of the arbitrator, but also the duty of diligence of the party takes
and I
an
think
important role.
Most of the firms we work with, or all the firms we work with, I think they take it seriously.
Yeah.
Because it's embarrassing for all the parties that if it's not only for the arbitrator. And I think if we had trouble, we had found it before we have appointed that.
And what I have been seeing is a tendency to over-disclosure.
Agreed.
Do you agree?
And that's probably, yeah, I mean, I haven't had any issues with it on any of my cases, actually. But we have had it, and happily it wasn't my problem to deal with, but we have had a recent example where there was a successful removal of our party-nominated arbitrator. And it wasn't my case, so I'm not completely across all of the details, but I believe the problem, and we have, we maintain our own databases, we check very diligently when we look at names. Obviously, the law firms do that as well. I think the problem came from too many instructions as counsel for this arbitrator by the firm. It was nothing to do with us. And it wasn't to do with, previous arbitral appointments. So, but yeah, there was a successful challenge, fairly early in the case, but still hugely disruptive and costly and difficult, frustrating. And, again, thinking always of the conversations that we as the in-house lawyers have to have with our internal clients. Another difficult conversation where they're going, how have you let this happen? Sometimes, things go wrong, but...
Thank you so much. Now we have some time to hear questions from this, like Elvis Presley would say, this lovely audience. Please, I think that Sophia raised the hands first, then we have some hands raised there and there.
Thank you so much. It was a really great panel. It's so nice to hear about it's such insightful views of big users of arbitration who, despite the shortcomings, are not completely disenchanted about arbitration. So that's really nice. And I wanted to ask, and especially a bit more for Kadi and for Savan, how much do you factor in confidentiality when you decide to put an arbitration clause or to go to arbitration? Is it really something that is important to you? Because there has been all of this push for more transparency by Alexis, for publication of awards, for instance, in the ICC, and the truth is we have not seen a lot of awards published. So I wanted to know how, like for the client, from a client's perspective, how important is it still that that arbitration is confidential? Is it really at the forefront of your mind when you think about arbitration, or is it just a side issue?
Shall I go first?
Yeah, sure.
So it's definitely a factor. Obviously, it's not down to me to draft the kind of shell precedent contracts, but we have arbitration as our kind of preferred dispute resolution. And, I'm sure everyone is aware of the different dimension that cases in the courts that are then in the public domain take on for us in particular. So yes, confidentiality is definitely a factor. We don't always see that necessarily respected even when we are in confidential proceedings. So I guess it's some, and there are certain sort of sage senior people in the business where we might be looking at kind of running a particular argument, and I'll say, oh well, it's confidential arbitration proceedings, and you almost get a bit of an eye roll. So yes, we like the fact that it's confidential and that's important, but I think we almost prepare for every eventuality, even, things not staying confidential.
For me, Sophia, it's in two parts. One is the availability of arbitration for company and availability of arbitration material in terms of awards being available. The first is that if I have an option, then you would like to pick it up. Like say if you are having an employee dispute, if you are having a reputational oriented dispute or an IP dispute, you would want it to be confidential because you say, okay, the information which is being discussed should be confidential. But do I have that option in courts? I don't. No. In arbitration, so we have learned to live with it, that these are confidential, so let it be confidential. Doesn't really impact us because being a large company which is committed to disclosures and listed at many exchanges, except some specific pieces of information which has IP value, IT value, and others, we are fine because it's known, that information are contracts. On the other side, what it's doing, and I was recently at CIRB and this point came up, how do you know about the quality of awards? How do you teach people that how to write an award, how to go about it? And with those limited awards on each ICC websites and all, it doesn't really give you the full understanding. It doesn't now in judiciary when you argue before the courts, you look at the judgments of the judge and you formulate your argument and what clicks with him, how does he look at it. Now you don't have that advantage in the arbitration that you can look at the awards of the arbitrator and see, okay, what is he looking for? Now you can look at it in are you trying to manipulate or are you trying to prepare? It's a question which works. So I think whether should more material be shared, discussed with the fraternity and among jurisdiction, so the knowledge from West can pass to the other places. I would encourage that there should be a little more openness to sharing that. But for company, you really don't care unless sometimes you say, oh, I wish this was confidential, that's it.
Thanks so much. My name is Kat from Skadden. I don't want to divert the topic too much into another panel, but I did want to ask all of the panelists really, and especially the in-house counsel, on views on third-party funding and how that plays into perhaps the assessment of, pricing the dispute or your conversations with your defense counsel. Thank you.
Go ahead.
I haven't actually dealt with, well, we don't necessarily use it ourselves, but we come up against it a lot. I haven't been opposite that issue myself, but I know colleagues who have, and certainly it's challenging and I think makes it more difficult. But I'm not sure I can add much more.
I think we have seen them a lot. We have not engaged them much. How we look at it is that why do you need litigation funding? The basic premises of this is that do you need cash? Do you need guidance? Because it's basically giving you the money to do it. Second is the expertise, because they also come up with some of them have their own huge legal teams who can add value to the case. Third, they know the best practitioner in the market. They have the experience, so they do bring a lot of things. But it really comes down to that if they are funding you, do you want that funding at that cost? Because some of that could be very expensive. And not as an Arcelor GC, but if you have to look at it, if I don't have the cash, then I would go with them because they can go and fight for you. If I have the cash, I won't. Or you may use them when there are a large number of litigants and you need someone to bring them together. Maybe
I
because
guess if you're using the defense counsel and you're trying to cost, planet Earth, that was quite an innovative way to bring a claim against Shell. Is there some sort of foresight that you're thinking through with your defense counsel when you're trying to plan it out.
Trying to win the case effectively. But yeah, no, we are seeing it more and more. And yeah, again, those aren't the cases that I handle, but yeah, it's certainly a challenge that is being kind of looked at.
I have still have the time, I think.
Yeah, we have time for two very quick questions.
Okay. Yeah, I do have a lot of questions to ask, but for the sake of time, I guess my question was directed to the panelist from Czech Republic. It's beyond my capacity to pronounce your name. Sorry about that. For SDS issue, maybe I can discuss you later. But I have a quick question. It's very interesting to know that the legal fees paid by your government. You compare two sets of cases. The fee was reduced from 4 million to 2 million. So, what kind of strategy did you take to reduce such huge amount of legal cost? Because the reason, I was often consulted by government agencies. I think your experience is very helpful.
Law firms in the room won't like this question.
Okay.
Well, I mean, yeah, I think it really helped. I think for me it was essential that I was in like a big law firm, like doing these investment cases. So I saw like how it was done, how it was structured, and that experience helped me when I was creating the internal team. And I saw where I saw like a big potential, for example, like to save costs, which in these big arbitrations, for example, just like gathering the documents from all like the state agencies, like all that review, like it's easily like.
Was it involve using a local law firm instead of?
Well, before I took over, yes, like the state, there was basically, they hired like the big international law firm, also law firm, like a local law firm. So like it added up and there was like no internal team. So I think the fact that if you are able to take, which we now do, like a good part of the work in-house, that does save a lot of money. Yeah, which also adds that if you have a good understanding of the market and the field, like I'm really able to do better decisions, like who to invite for a particular case, and like have a better competition, so you can get much better results.
Okay.
So,
my question is actually very similar to yours, but complementary in a way. Fernando Martins from Clyde & Co, so thanks for the panel, it's great. What sorts of tasks did you find that worked well to bring into your team? I assume that's for all panelists, and it will depend on the size of each team. What kind of tasks in general can be done internally and work well, and what sorts of tasks cannot be done internally and do not well? Just generally speaking, I know it's a broad question, but.
Yeah, I can tell you quickly from my experience. For example, for investment cases, like you generally say, always like it's 80% of the case are facts, and which let's say if the case is Czech Republic, so it's like thousands of pages in the Czech language, which are like spread among some like agencies. So I feel like I have the junior colleagues in my team who can very well like go gather all that, do that initial review, kind of organize all that. We write these initial memos about the case, like all the facts, like research in Czech law, kind of do a lot of this heavy lifting. What I expect, and when I hired an external law firm, like there I want the added value. So in a way, we already have like we give them all this like information, but already kind of served, if you want to, and with them I discuss like the strategy for our case, like what the lines they take. We agree on the outline, let's say, for our submission. Then we do the first drafts, but then again, like I give it to them and I say make it better. But I work usually like with partners, like really like senior associates, like so more on the more experienced side, and like help us make it better, like review it, all that. And then I again work with them a lot for the hearings, like we divide the openings. Like, for example, like, yeah, naturally, like I do more facts or check law, but I use experience counsel much more, for example, for cross-examination, because they can make a difference. So I really see, like, we work very closely with the firms, and it's usually like smaller team, more on the more like the experienced lawyers, and there I'm like happy to pay that because I really see the added value, plus like of like myself or my team, like we can like learn from that a lot, and I think it can be a win-win cooperation.
Katie?
Yeah, it's a great question. I could almost reformulate it as what do I most miss from private practice? Because, we are kind of one step removed. We're managing a huge number of cases each in our team. So, we just can't get as involved as we might have previously been. We deal with a lot of kind of pre-dispute work. We might do the correspondence ourselves, but then once we've got active proceedings on foot, we do look to appoint external counsel. But yeah, very much involved. We like to be really hands-on about everything, from the written submissions to the strategy. Obviously, deal with the witnesses and the factual investigations like Jarek was referring to. Obviously, it depends partly on how much time have I got that day and how passionately do I feel. The example I talked about right at the start in my pros and cons of where I felt, perhaps not the right response initially from the tribunal meant that the procedure was kind of going off course. I was very much in track changes editing, putting ranty comments into the draft. It was a perfectly good draft from counsel, but I was like, we can't be sophisticated about this. We need to be as blunt as possible. So it depends on the day. But obviously we have an internal client to manage on every case. So there's a lot of strategy and a lot of reporting as well, which takes a lot of our time.
So thank you so much for the questions. It has been a privilege to talk to in-house counsel that go well above and beyond duty, and thank you so much.